The victim in her statement under section 164 submits that he went with the petitioner to the aunt's house, to his aunt's house, পিসির বাড়ি, to his. Though the petitioner has disclosed that there was physical relationship, however, there are no such allegations of any forcible sexual assault. The victim has refused to undergo medical examination. Charge sheet has been submitted
Not yet, charge sheet is pending.
in view of the considering the above, I'm inclined to enlarge the petition anticipatory bail. থাকে কিন্তু যাই হলো subject to the petitioner shall meet the investigating officer once in a fortnight until further orders. Petitioner shall join in investigation and cooperate with the investigating officer. Disposed of.
May kindly not enter in the jurisdiction of the child.
Petitioner is directed not to enter the jurisdiction of which
de facto has expired. And she is aged about 72 years, my lord, and she is suffering from Parkinson. The petitioner number 1 and the petitioner number 2 is her only son, and the present case sprouts out of a matrimonial dispute or the dispute related to the property, and it is the counterblast of the FIR which was lost by the wife. The FIR which was lost by the wife is at page number 17, my lord.
Whose wife?
Wife of
De facto complainant.
de facto. But the de facto has
Petitioner number 1 is the wife of the de facto complainant, and 2 is the son of the de facto complainant. And there is a
The complainant has lodged complaint against his wife and son.
Yes, my lord.
yes, my lord. And my lord, the wife has lost her complaint at page number 17. And the present complaint which the husband has lost, it is a counterblast of the FIR which was lost by the wife. The wife complaint is at page number 17.
My lord, this is the 161 statement of the eyewitnesses.
There is
And
matrim-
medical also there, my lord. CCTV footage also there.
Who has died? You said somebody has died? Who has died?
Expired after an amicable settlement has taken place between the petitioners and the de facto after the husband has expired. My lord, after lodging of this complaint, the complaint was lodged under section 156(3). The first complaint was lodged by the wife, which was at page number 11, and the case was initiated under the Arms Act because the husband has opened the fire and the wife also got injured, my lord. It is at page number 17, my lord, the FIR, which was lodged by the wife. My lord, the case was initiated under section 498A P07, read with 35 of the Arms Act. Case number 17.
17.
Yes, my lord.
Yes. Seventeen is a
FIR.
give deed, no?
FIR lost by the wife.
Page 17 is a give deed.
In the supplementary affidavit.
Oh, yes, yes. Sorry. Page 17, yes.
Yes. My lord, the case was initiated under section 498A 307, read with 35 of the Arms Act, my lord.
Okay.
And the husband got arrested, and after he was released on bail, my lord, he lost the counter FIR. Sorry, counter complaint. It is at page 11, my lord. It was initiated under section 156(3). My lord, it is just a counter blast, and at page number in paragraph number 4, my lord, you'll find that the main dispute was related to the property. Paragraph number 4, page number 12. And my lord, there is a long-standing dispute between the husband and wife. If I call your attention to the supplementary affidavit, my lord, kindly come to page number 4, my lord. In the supplementary affidavit, page number 4. My lord, this case, the wife has lost this domestic violence case against the husband in the year 2012. And thereafter, my lord, in this case, the wife got the final order related to the protection order, page number 14, my lord. Page number 14, my lord, in the page number 15, you'll find the final order of the court which was passed against the husband. The respondent is prohibited from committing any domestic violence and restrained from dispossessing the petitioner from the said household. And thereafter, my lord, an amicable settlement was at page number 15, last paragraph, my lord.
I'm coming to the
Hopeless.
12, 20, 21. This FIR is of 2023.
That an amicable settlement has taken place between the petitioners and the husband, and on account of this amicable settlement, my lord.
What is that? Give deed. This give deed has been executed.
The son had gifted the property in favor of the father, who is a de facto in this case.
Okay.
And my lord, after this amicable settlement, this gift deed was executed in the year 2023, and after that, in the year 2024, the husband has expired. My lord,
After filing of this case in 2023, the give deed has been executed.
Yes, yes, yes.
Oh.
Hence I prayed for bail, my lord.
Yes.
My lord, there are four 161 statement of eyewitnesses, my lord. And my lord, medical report is also there. CCTV footage is also there, my lord.
Where is the
About
medical
the-
report?
Medical report, my lord, 25 to 31. 25, 26, 27, 28, 29, 30, 31. Head injuries are there. Several injuries are there, my lord.
25 hypertension.
My lord, apart from de facto complainant, there is another victim.
Who is that?
My lord, I have to get the name. Once in 161 statements, my lord, page 14, 15, the name was mentioned. 14, 15, 16, 17.
Indru Rai. Where is his injury report?
My lord, 25 to 31 is the medical report, my lord, and
Ashun.
My lord, I also.
Learned advocate for the petition. Ashun. Learned advocate for the petitioner submits that the petitioner number 1 is the wife and petition number 2 is the son of the de facto complainant. There were long-standing civil disputes between the de facto complainant and his wife, petition number 1. Previously, petitioner number 1 lodged a FIR in the year 2021 over an incident in which she sustained bullet injuries. She sustained bullet injuries?
no, my lord.
The wife, he was.
He fired a blank
The
fire.
wife was physically assaulted, my lord, and the husband opened a blank fire in the air.
Yeah.
And they called it the
On an
property-
incident in which she sustained serious injuries on being assaulted by her husband, the de facto complainant herein. After grant of bail in the case initiated at the instance of the wife, the de facto complainant has falsely implicated the petitioners in the present criminal proceedings. The disputes have been amicably settled by and between the parties, and a gift deed has been executed in favor of the de facto complainant by the sun on
26
20
May
26th May 2025.
23.
3. 26th May 2023. Subsequent thereto, the de facto complainant has expired. The petition number 1 is suffering from Parkinson. She seeks for grant of anticipatory bail in favor of the petitioners. Opposing such prayer for anticipatory bail, learned advocate for the state submits that in the said incident, the de facto complainant sustained head injuries along with his security. He seeks for dismissal of the application. It is the case and the materials on record. Admittedly, previously the petitioner number 1 had lodged a complaint before the Matigoda police station, registered as Matigoda PS case number 609 of 2021 under section 498A/307 of IPC, read with section 35 of the Arms Act. The complainant thereafter lodged the present case against his wife and son. The injury reports of the complainant and one Indro Kumar Rai does not reveal of any serious injuries. Oh. No, seriously, Kiradin. Shows fracture of lateral end of clavicle. End of clavicle. He was admitted to the hospital.
My lord, Indro Kumar, I have to fill that.
Captain rank. Considering the fact that the case has initiated out of family dispute and the nature of offense. Where are the prescriptions of this petition number 1?
Petition number.
Regarding Parkinson, my lord.
Huh?
My lord, it's not right with me, but I can submit tomorrow. I can fix it tomorrow. If Passover is made, I can submit it today also.
What is the name of the son?
Aman Subba.
বলো কেটে দাও কেটে দাও ওই কনসিডেন্সে কেটে দিন there are allegations against page number 2 along with others of attacking the de facto complainant. Consider the above. I am not inclined to extend the benefit of anticipatory bail in favor of petition number 2. So far as petition number 1 is concerned, it is found that several litigations, including applications under Protection of Women from Domestic Violence Act, was filed in which protective orders have been passed. Consider the above, I am inclined to grant anticipatory petition number 1. Correct. Partly allowed. Mother is allowed, the son is rejected.
Rest more.
Article 17. The petitioner. The deceased victims was in a love affair with the FIR accused person. That is the girl. The girl was arrested and later on, she was released by the intervention of this honorable court. Here, this particular petitioner happens to be the father and mother of that of the girl, who has been specifically implicated in the FIR. Page 10 is the FIR. Even these particular petitioners have not been named in the FIR.
No, they are parents of whose parents are they?
Yes, ma'am. She has also been released. They were in a love affair, my lord.
The girl was ignorant.
She committed the boy committed suicide, my lord. Thereafter, the girl was arrested. She was released, and these particular petitioners are the father and mother. My lord, they are not, my lord, the FIR named accused person. Even my lord, other two, my lord, the uncle and aunt, they have also been implicated. They were also, my lord, got anticipatory bill.
PSC Sarkar, Pappu, wife of her. And what is the apprehension if you are not named in the FIR? Charge sheet has been submitted against you.
No, my lord, charge sheet has not been submitted.
Then you are not- you are nowhere
Petition
in the
number,
FIR.
petition number 2 is the FIR name accused in the formal affair.
Petition number 2.
Petition number 2, Mitali Sarkar. But petition number 1 name not in the CD also. Formal affair accused number.
Mitali,
Yes, person. 4. And to unknown person, but not named in
known
the.
person. Wife of Pappu. Pappu and his wife
They have also been, my lord,
granted.
granted bail, anticipated bail.
Where is?
My lord, I have not annexed, my lord. If your lordship kindly permit me, my lord.
Is the statement, in the statement,
Yes,
their
Lordship.
names are transpiring?
No, Lordship. Lordship, this 164 statement, Lordship. Other two person granted
Where
for
is the name
38
of
bail, Lordship,
Mitali?
they are order sheet in the CD, Lordship.
Where is the name of Mitali in the written complaint?
No, my lord.
It is not there.
No.
There. This is not maintainable. Withdraw this application.
My lord, police did not have to do
The
it.
police can harass. Here's the police.
Hmm.
There cannot be a blanket order. And others, everybody will come in this case and say that I am included in others, so I entertain my application for anticipatory bail. If you are named in the case diary, if there is statement against you, then can this be maintainable?
But they have conducted raid, my lord, not them. Right, my lord, the girl was in custody, but several raids were conducted, my lord. That is the apprehension, my lord, which compelled me to file this application.
One 161 statement.
161, Your Lordship. 9, 10, 11, 12, 16, 17, 18. 7 was sisters.
Well, may I permit to produce the bail orders? My lord?
Bail orders I have seen, but Pappu and his wife has been named in the FIR.
Named, the name, if I am allowed, and they have been granted bail.
But you are nowhere in, neither in the
No, my
case
lord.
diary.
In spite of that, my lord, the police.
How can there be a blanket order?
You know the touch card नहीं anticipatory bail. Oh, अच्छा अच्छा. आगे पहले in the CD Lordship, there are two order, 438 and 439.
Hmm.
But Lordship, till to date, PM report not collected by the IO.
Badal has been arrested.
No, Lordship.
Nothing is there. There is nothing, sir. Withdraw this application. Withdraw this
No, the
application.
police is hounding against me,
What
my
can
lord.
be done? If it is not there, then the blanket order cannot be given. Everybody will approach the court for anticipatory bail.
But I am apprehending arrest, my lord. The police on several times you have conducted. very well.
Apprehending arrest, there has to be a basis. It says that if you have an apprehension which is backed by facts of any non-bailable offense, then only can it be entertained. I have searched through entire statements. Nowhere in the written complaint your name is not there. In the formal FIR, no. In the statement, no. 164, 160. Parents of the girl.
Lord, the accused person's name may not be, my lord, included in the FIR, but so the police is hounding against me, my lord.
So the police, we have to take the course as provided under law.
Lord, despite
police
the
can
fact
go
that
after
there is no
anybody.
specific name, my lord,
Huh.
that I have not been arraigned in the FIR. In spite of that, my lord, they are hounding against me.
There are other provisions in
Even, my lord, the
438 you
FIR
can.
accused person has already been granted bail, my lord.
Who?
Bail and anticipatory bail.
Who?
My lord, the principal accused, my lord, the girl, she has been granted bail. Pappu, my lord,
If
that is
you
the
are
uncle and
not
aunt.
accused in a particular proceedings, can 438 be granted? Tell me this thing. If it can be granted, I will allow this. I tell you that there is no reflection of the parents of the girl in the written complaint, in the formal FIR, in 161, 162. I am with you. And the police is searching, but we are fixed with the 438. We have to concentrate on that. You cannot have a blanket order.
And Lordship, in the city, there is no mention that police conducted raid to arrest those two persons, Lordship. There is no mention in city.
Yeah.
No, raid এর কোনো ইয়ে নেই এদের।
What will you do? On the prayer of learned advocate for the petitioner. Learned advocate for the petitioner seeks to withdraw this application. Application is dismissed as being withdrawn.
Diploma, Lordship.
I did anything. Thank you.
Earlier rejection order, Lordship.
What is your name?
Pappi Shokta. This number 7. State the petition has been due to Lordship, initial stage of investigation and co-accused were abscond, Lordship.
Thereafter, Lordship,
Co-accused was arrested, Lordship, and granted bail, is number 9, Lordship, and charge sheet has been also filed.
You there, no cases can be equated on cards.
Indian citizen, Lordship.
He is in registered Kotwali, Gentlemen and Foreigners Act and section. What is 224? And
189 IPC.
303?
303 379 and 317 2 is 411 of IPC.
Yes, other cases of Lordship, the details, Lordship. The charge sheet by Lordship, no privacy evidence against this petition, only the co-accused statement, this petition and then transfer, Lordship. There's no eyewitness, Lordship, no money transaction or mobile phone details, nothing, Lordship.
Well, 3 BSF personal statements named this petitioner. Page 12, 21 and 22.
12?
12, 21 and 22.
Written complaint.
Learned advocate for the petitioner submits that the petitioner renews his prayer for anticipatory bail. Pratham, learned advocate for the petitioner submits that he is an Indian citizen. Upon completion of investigation, charge sheet has been submitted and there are no iota of evidence against the petitioner. 6 for this granting anticipatory bail in favor of the petitioner. Of prayer for bail and an advocate for the state bail anticipatory bail. An advocate for the state submits that the involvement of the petitioner is revealed from the statement of the BSF personnel. Upon considering the materials in the case diary, the prayer for anticipatory bail was previously rejected by this court. He seeks for dismissal of the application for anticipatory bail. It is the case diary and the materials on record. It is found from the statement of the witnesses that this petitioner on the date of incident played away from the scene of occurrence. Upon perusal of the case diary, the anticipatory bail prayer was previously rejected in CRMA 310 of 2025 of the petitioner, bail prayer of the petitioner. There is no change in circumstances. Rejected, dismissed. Therefore, কত নম্বরে আছি কি হলো
Shyam for this state.
how many what is the name of this petitioner Jairul has been rejected earlier.
Earlier rejected, Lordship. No change in circumstances.
An advocate for the petitioner seeks to submits that the petition does not intend to trace this application. In view of the above, the application being CRM 8730/2025 stands dismissed, being not traced.
Grateful, Lordship.
Item 20. Item 20, my lord.
20, I am from the state, madam, holding the case studies.
Lord, in total, my lord, 12% have been arraigned in the FIR. My lord, I have been instructed, my lord, that all of them, 7 except this petitioner, have been granted bail. My lord, by the learned court bail. My lord, I have to obtain, my lord, the certified copies, my lord. Allow me, my lord, 2 days time, my lord. Fix the matter on Monday, my lord. I will. That will be, my lord.
Mohammed, what is your name?
My lord, Munu Sheikh. That is, my lord, serial number, my lord, 6. Next page, page 9.
Munu.
Munu Sheikh.
Your names. Document.
25. Let me see. How many accused are there?
Well, 12. Fine.
12. Doctor's calculation why the death was destroyed.
Against all,
What is your-
my lord, warrant of arrest and execution report is pending, my lord. So I have to also ascertain, my lord,
Whether they have
if
been
there is
filed,
any proclamation or attachment is
issued
there
on
or not.
an advocate on the prayer of learned advocate for the petitioner. Then I'm not passing any order. You
My lord, I'm definitely.
on the prayer of learned advocate for the petitioner. Release this matter on Mr. Chakraborty. When this report can be obtained?
Tuesday.
Monday. Not Tuesday. On Monday.
Monday.
2 days are there.
Monday. morning.
And
21. যেগুলো না নট টুডে টুডে হয়েছিল বলে দেবেন আমাকে ব্যাকে দেখে নি নট টুডে হয়েছে কিনা ডিসমিস করে দেবেন
নাই তো আজকে।
কি বলে গেলেন?
সুভাষিস ছিল তো এটা তো। হ্যাঁ।
জগদীশ চন্দ্র রয়
না সুভাষিস নাই। ও না,
জিপুর
যোগেশ চন্দ্র রয় এটা।
হুম T20.
মার্ডার।
The case was initially started under 307.
Yes, মার্ডার। চার্জশিটের alert. The eyewitness 164 is there, my lord. Petitioner is named in the 164.
Sajidul.
যোগেশ চন্দ্র রায় কে? May I hand up the CD, my lord?
No, wait. None appears on behalf of the petitioner. State is represented. You have the case diary?
Yes.
Earlier, this petitioner approached this court? No. Copy you. Raise this matter on day after tomorrow, on the Friday. For ends of justice, the matter is adjourned. On Friday.
First application.
On Friday.
Right.
Mr. Vishwas, in this case, one WPA was issued against this petitioner.
What?
But in revisional application, that was set aside.
And that can be done.
That was set aside.
Yes.
Now, whether subsequently 84 has been complied by the court and this petitioner has been filed or not, you just find out. Yeah.
On item 22 and 23 out of arising out of same PS case number,
Yeah.
can it both the
22,
petition?
22.
Milods, I appear for the de facto complainant, Milods.
In
Milods,
which
may I-
one? In which one?
Milods, in both, Milods, because these, I believe, arise from the same FIR 22 and 23.
22 and 23.
22 and 23 not connected application.
Milods, I am requesting, Milods, a copy be served on me and let this matter be kept tomorrow so that, Milods, I can also assist your lordship.
Lord,
No.
if you want a copy of the applications, Lord, you can take it up with the prosecution.
No, Milods, I have a right, Milods. The complainant has to serve it to me.
Sir, please. Not the de facto complainant's role is limited to assisting the prosecution. If he wants a copy, Lord, you can take it up with the prosecution. Lord,
Fraudulent. What is it? 420?
yes, ma'am. Lord, the FIR, Lord, the complainant happens to be a practicing advocate. As a result of which, Lord, the FIR happens to be a criminally exaggerated one. Lord, a simple civil dispute, a simple contractual dispute has been given a criminal color. And my lord, the entire family has been implicated. My lord, we happen to be the partners of a my lord legacy firm of the town of Jalpaiguri. Goes by the name Silver Queen.
Silver?
Silver Queen. Silver Queen, my lord, subsequently due to expansion of business, there was another business opened which went by the name Gold Diamond Silver Queen. Now, my lord, this was essentially a family run business. Now, my lord, this has a reputation of at least 50 years in the town of Shillong. Now, my lord very well knows that in the last 5 years, after my lord COVID, the gold prices have my lord risen unprecedented. As a result of which, my lord, there have been people on both sides of the spectrum. My lord, big jewelry companies have my lord benefited from it, and my lord, relatively small sized firms like ours, my lord, we are on the other side of the spectrum who have lost money. Now, my lord, how the jewelry, this entire business works, my lord, small, relatively small sized firms, my lord, they pool money from customers. They pool money from customers, and those sums of money are known as unsecured loans in the books. The customers, my lord, are paid a certain amount of interest. That is exactly the transaction which has occurred in this case. In the year 2021, this complainant happened to, my lord, transmit certain funds to Silver Queen and Gold Diamond Silver Queen. He was, my lord, promised an interest of, my lord, 12.5%. The first installment, my lord, which arose on the next financial year, amounting to rupees 4 lakhs, was paid to him. TDS was paid on that amount. He accepts that in the complaint, and now comes up with a plea that I have defrauded him. Lord, this is purely a case of a business dispute. Lord, this business has run into massive losses because of this. Lord, the unprecedented rate that the gold has
So
gone.
this amount was given as a loan.
Yes, my lord. I'll show it to you, lord. It appears to the loan admits to the fact that the first interest was paid to him. And he very cleverly mentions that amount as a relatively small amount. However, my lord, that is not a relatively small amount. That was an amount of rupees 4 lakhs. I have paid TDS to it, on it, and my lord, he has filed his income tax return on that.
Where is the memorandum of understanding?
Yes. Yes, my lord, that is also a very important scenario. I being the counsel of my client, my lords, I had personally, because the complainant happens to be a practicing advocate.
No, no,
I
Milords,
personally-
may I interject, Milords? I'm sorry, Milords.
Sir, please.
While I don't have a copy, Milords, my learned friend is making wrong submissions. Milords,
Milord,
on the fact,
I-
Milords, I have to clarify. I'm not sure where the complainant practices. I don't have that information. I don't know why he's saying that again and again.
He is a member of the Shirvadi Parliament. But I, as my client's counsel, I happen to, my lord, personally visit the complainant with this memorandum of understanding, my lord, which starts from page 30.
Which?
Page 30. Page 30 onwards, my lord, is the memorandum of understanding, which I had personally drafted and handed over to the complainant. Page, my lord. He refused to execute this. Page 39 onwards are the checks that I have, my lord, executed in his name. Page 39 onwards, the entire amount. The only thing that I wanted from him is some time. That is all. Because Lord will kindly appreciate that I have to come back. I have to start the business, get the business running, and pay off his loan. He is not giving me that opportunity because he has lost this FIR and the police is after me.
No,
Lord,
no.
I am a patient of myasthenia gravis. It's an acute neurological disorder. My daughter, my lord, I hate to bring this back. My daughter is a patient of thalassemia. We went to Calcutta for our treatment, for my treatment as well as my daughter's treatment. I, my daughter, my wife, my son, and behind our back, my lord, this FIR came to be lodged. After that, the police are running after us. May I bring this fact to your lordship, my lord? Apart from this family, Chandra Prakash Sinhal, Sarita Sinhal, and Chetan Sinhal, all the other accused persons are on bail. 2 have been granted bail by this honorable court in an anticipatory bail application. 2 have surrendered before the learned trial court and obtained regular bail. Purely a contractual dispute, my lord, by reason of the complainant being an advocate and being an influential person in the town of Jalpaiguri, lord, this family is suffering this harassment.
Milords, may I, Milords, on
These news articles, my lord. These are the news articles in bold letters, my lord. This family has suffered such an amount of defamation, my lord. This is not totally unfortunate what is happening to this family. Lord, if your lordship is of the view that this is an elaborate matter, my lord may take it up tomorrow, my lord. I'll satisfy your lordship. There is nothing on it. I have sufficient documents to prove, my lord, that this is purely a contractual dispute, given a criminal color, and supported by, my lord, the latest honorable Supreme Court judgment, which says, my lord, for recovery of money, criminal proceedings cannot be initiated. Justice Pardiwala has been totally clear in his words to say that criminal color cannot be given to a money recovery dispute. The dispute was in the year 2021. Today we are standing in 2025. That is barred by limitation. He has not approached the learned commercial court.
But prior to signing of the memorandum of understanding,
Yes, my lord.
the transaction has taken place because you say that they refused to sign the memorandum of
Yes.
understanding.
Yes. No, he paid me the money in the year 2022. I'm sorry, yes, perhaps 2022. The first installment, the 12.5%, the first amount that I was liable to pay, I had paid in the financial year ending March 2023. That amount, my lord, I had paid TDS upon that for 4,57,000, amounting to 4,57,000. He filed his income tax return on it. Subsequently, my lord, this business went into a spiral and went into a downfall.
Milords, what
Sir,
my learned friend is saying now that he's in a money lending business.
No,
Milords,
I'm
he's
not
a
in the money
dealer.
lending business. It is your client who has paid me.
Milords, I will make my submissions, Milords. He's not even placed what the complaint is, Milords. What my allegations is, he's not addressing that. And the amount paid is, Milords, 85 lakh towards a gold jewelry scheme.
No, there is.
That's
Yeah,
my
yeah.
allegation, Milords. But
Yeah,
in
brought
any
up the
case,
story
Milords,
of
I am
gold jewelry
requesting,
scheme, Lord.
Milords, today
Before
I am
this honorable
requesting,
court, in the other anticipatory bail applications, this honorable court inquired them, what do you have to show about this gold jewelry scheme? They could not come up with anything.
Milords, I will,
Kindly see
Milords,
the case diary.
make
If there is any document to show that there was a gold jewelry scheme run. On the other hand, I will show your lordship the ledger account and their TDS account to show that this was an unsecured loan. That is how the gold jewelry business works, my lord. At a relatively smaller level. We pull in money from customers And my lord, we promise them a certain interest and a particular interest which we repay. And at the end of the term, whatever is, my lord, orally contracted, at the end of that term, we pay them back the money. And this money is rolled in the business. It is used as a work.
That can't be the case, Milods, for the simple reason there's a money lenders
This
act.
man also paid, my lord, 65 lakhs in exactly that transaction. That is what the transaction happened. I'll show you lots of the documents.
65 has been paid back.
65.
Nothing.
The
Plus
first
not even
installment was paid back 4 lakhs. After that, my lord, I failed to repay. And
No,
right now,
Milods-
my lord, the money recovery is barred by limitations. That is
Milods,
why in the
may I-
month of May 2025, they come up with this plea, come up with this FIR behind my back. When I'm in Calcutta for my myasthenia gravis treatment and, my lord, my daughter's thalassemia treatment. And after that, my lord, the police is after.
Milods, may I just make 2 or 3 points, Milods?
Continue.
Milods, your lordship may direct them to serve a copy, Milods, on me.
Give a copy to the de facto complainant if he intends to make any submission.
Grateful, Milods.
Deeply grateful.
Tomorrow we'll take it up, not today.
Yes.
You are for the de facto complainant?
Yes. Yes.
Milods, my colleague is there.
Yes.
Milods, can I request day after, Milods, if that's convenient to your lordship, Milods? There's some personal difficulty tomorrow.
Friday I have difficulty.
Milods, Monday, Milods, in that case, Monday, Milods.
Next week, Malak.
Monday, Milods, Monday, your lordship may take it.
Why, sir?
Milods, some personal difficulty tomorrow, Milods. Either Friday, Monday, subject to your lordship's convenience, Milods. I'm sorry, Milods.
Please, Devan. Monday, several matters are there. Monday, several matters are there.
Please don't.
Okay, good. Tomorrow.
Milods, one day, Milods, indulgence, Milods. There's some difficulty, Milods, tomorrow. Milods, may keep it on Monday, Tuesday, Milods, whatever
Monday.
is convenient to your lordship. Grateful, Milods.
Just date the Monday. দুটো both the application. দুটো related. Oh, चलिए देखिए यही सब
Your Lordship can allow me. Hello, am I audible, my lord? Item number 29.
tomorrow.
Fine, my lord. Kindly take it in Monday, my lord. I'm coming,
20?
then I'll come back, my lord. My
20?
wife is hospital. Monday I'll come, my lord. Kindly take it 29. My lord,
Let it
others
be
are-
called tomorrow. Let some of a junior remain present and ask for an adjournment. It will be fixed on that day.
Yes, my lord.
चलिए
আমাকে তো পছন্দ
I think 146.
No. আমি কোথায়? কালকে তো এসেছিল আছে নাকি?
146.
না আসলে পাস হয়ে গেছে।
But I come up before the lordship to stay the warrant of arrest. This case, my lord, warrant of arrest has been issued on 30th August 2025. Alright, kindly see the order sheet, last page, sir. Alright, I was all along on bail, I never misused the liberty. Alright, due to miscommunication between the advocate and the parties member. This one,
He is accused to have insulted
without any stay, but it has been issued. Or kindly pay the warrant and I will surrender. But actually, they went outside for their job, due to miscommunication, manner. I never misuse the liberty. I all along there.
Yes.
Only lordship, only to ensure he settled the lordship.
Go and surrender. Issued up.
Continue same day.
Huh?
Can stay the warrant and continue same day.
Why? What is your 2016 when you were granted bail?
But before the
You see.
trial court, I was granted bail now.
What is this case? T76.
376, 511. Attempt to.
Both accused persons were absent. How many witnesses have been examined?
But
Where are the other orders? When were you enlarged on bail? Please that order.
I have to be in that.
Only 2 orders will not suffice. How many days you have absconded? The CS witnesses are to be examined 8, 9 and 10. And for your absence, the trial is delayed. Then
But
how do you claim that it will be stayed? No, I will dismiss this application. No, no bringing this order. First of all, you allow this application to be dismissed for default. Now again an application for restoration filed, revisional application restored. Now we say that on such and such a 2 dates I find that you are absent. The orders we have annexed, 2 days you are absent, the date is fixed for examination of the witnesses.
Yes, that is.
Then
But I have to bring all orders, man. Kindly give me some.
when you are enlarged on bail, have you stated? When the bail was granted, CORT was directed to produce the accused. He also did not respond. What was the option open to the court?
But I will produce all the order sheet.
Not necessary. See, witness was present. Dr. Rajiv Biswal was present. He could not be examined. He had to be discharged since you were not present. Ashun. Affidavit, late learned advocate for the petitioner submits that he has all along attended the court. He seeks for stay of. This is an application for setting aside the order dated. Order number 17 dated 13th August 2025 passed by learned additional district judge district sessions judge have a district and sessions judge, court Jalpaiguri. In sessions case number 321 of 2016, within bracket arising out of Moinaguri police station case number 356 of 2015, dated 22nd July 2015, under section 448, 323, 324, 376, plus 511, 34 of the Indian Penal Code. That's all a submission to. Opposing such prayer, learned advocate for the, on the contrary, learned advocate for the state submits that due to absence of the accused persons, both have come up, both the accused persons, the examination of the witness could not be taken up by the court. Produce the orders annexed to the application. It is found that the accused persons on 16th June 2025 was absent without states. On such date, CORT was directed to produce the accused. On 13th, order number 17 dated 13th August 2025. On 13th August 2025, despite there being direction upon the CORT to produce the accused persons, such order was not complied. Accordingly, warrant of arrest has been issued against the petitioners. In view of the above, this court does not find any infirmity or illegality in the order passed. Accordingly, the application being CRR 426 of 2025 stands dismissed. All connected application interim order is vacated. On 13th August, witness was also present who could not be examined due to absence of the accused petitioners. ঠিক আছে? Examined. Absence of the petitioners. Next. Yes.
148 million. So here the Provident Fund Authority has lodged a complaint against the directors as well as the pen under section 405 and 409 of the Indian Penal Code. The FIR was lodged the year 2014. With an allegation that an amount of money which was supposed to be deposited as a provident fund, supposed to be disbursed in favor of the labor, has not been deposited and it has been misappropriated.
You are up against which order?
ID ground. Page 41.
Wash in the status.
That is the FIR.
41.
Page 40.
Yes.
Page 41. Page 41, yes, you're doing fair. You're fair. Actually, for this. So the,
Okay.
it's my humble prayer, my lord, say that transfer brief to me. Lord, the lordship, my lord, allow me, my lord, 2 days time, my lord. I have not properly gone through, my lord, the documents. Even, my lord, the Provident Fund and Miscellaneous Act, my lord, the book is also required. Or inadvertently, I have forgotten, my lord, to bring the book. The lordship kindly, my lord, the matter on Monday, my lord, I will be faithful.
You are for the state.
I've got the statement. I've got a in front of it.
On the prayer of learned advocate for the petitioner list this matter on Monday under the heading contested application.
Okay. Okay, 149.
Lordship, I'm appearing on behalf of the opposite party.
অগ্নিভোগ বন্দ্যোপাধ্যায়। Yes.
So the allegation against the petitioner under sections 117.
My lord, before he argues, my lord, please allow me.
Yes, please.
My lord, I have received today the certified copy of the case diary. Some pages are quite illegible. I have to bring the original case diary in this case, my lord. Kindly accommodate me, my lord, next week, my lord, without going to the original case diary, I cannot assist your lordship.
On the prayer of learned advocate for the state. Release this man Monday. It is same heading রাখুন। শুনতে ওটাকে না কন্টেস্টেড নিয়ে যাওয়ার দরকার নেই, যেটা বললাম কন্টেস্টেড যাবে এটাকে সেম হেডিং এ রাখুন, মোশনে রাখুন, কি আছে। আগের থেকে যেটা কন্টেস্টেড করলাম ওটাকে সেম হেডিং এ রেখে দিন মোশন।
It's the brother-in-law of my wife, my sister's husband.
Sisters?
Sisters, my wife's sister, elder sister, her husband is the opposite party number 2. Out of a matrimonial dispute between me and my wife, so this FIRs were registered, all these complications were built up, but presently the petitioner here, who is the husband, and the sister-in-law of the opposite party number 2, who is the wife, my wife, all the disputes and the differences in between us have been amicably settled between us. And memorandum of understanding was executed between us, and furthermore, we have also filed for dissolution of our marriage, and there is no grievances against both of the parties they have.
Deepak Kumar More, son of Pawan. How many cases have been initiated?
There are several litigations were initiated.
How many revisional applications are pending?
Divisional applications are pending from my side and.
What is the name of the mother of Pawan Kumar Agarwal?
Mother of Pawan Kumar Agarwal is not the party, it's the wife of the Pawan Kumar Agarwal, Kamta Agarwal.
হয়তো আছে কবে
He is the
রাখলাম
mother-in-law. Here is the Ayush Agarwal, he is the brother-in-law of the number two. The
মাটিগাড়া
same party, same family member.
Same family.
দেখো তো কালকে ছিল সবগুলোকে একটা জায়গায় করে দিই।
There are two other cases also listed today, 155 and 156. It also arises out of the same dispute in between all the, and the parties are same.
গতকাল ছিল না
in 155 and 156.
গতকাল একটা ছিল না 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 এদেরই এই পাওয়ান আগারওয়াল
Yes. Yesterday also.
It was there yesterday also.
Yesterday we took
এগুলো কবে
একবার আমি বলে দিচ্ছি
কবে ওটা প্লেস হয়েছে তো এটাকে ওখানে দিয়ে দেবো and where is the affidavit by the complainant that the matter has been amicably settled? What are the sections? The sections can be amicably resolved.
175 156
কবে গেছে
এটা কিন্তু আমি আজকে এটা কিন্তু আজকে 155 আর 156 আজকে যেটা ওটা আগের দিন ছিল 175 176 না 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 যাইনি
এটি
গতকাল 173 176 আসেই
ও তাহলে এটাকে তো ক্লাব করে দিলে আমার তো কাজ হয়ে যাবে যদি মিটে যায় তাহলে দিয়ে দেবো Can you just find out from your client how many cases have been initiated so that the revisional applications one after the other can be listed and disposed of? The matter is amicably settled.
Yes.
Mr. Pal, yesterday there was a case-
Two matters are here in the list. One matter is not appearing, my lord.
How many revisional applications have been filed?
I have filed four.
Four.
In
Okay.
one matter, simply I have to withdraw it because I have challenged the order of the ACJM, my lord. And in another, I have prayed for quashing of a proceeding initiated by the husband, and the other by the father-in-law and the mother-in-law.
So give the numbers when those matters are scheduled to come up. Provide
I'm
those
handing over the
numbers,
number, my lord.
and these two matters will appear with that. ওই নাম্বার গুলো কত আজকে কি আছে লিস্টে
Yes, madam. We are all matter that is there in the list, 155 and 152.
অল্পই আছে
155
155 and 156 is ours.
150
155 and 156. And two matters not listed in the list, my lord, I shall provide the number. One fifty.
ছটা 6
So what, seven matters?
these matters can be disposed of amicable settlement
All the matters.
Friday serially
এই দুটো
আর নাহলে তুমি করে নাও, মার্ক করে নাও যে এই সিআরআর নাম্বার দিয়ে যদি সিরিয়ালি না আসে তাহলে প্লেস করে দেবো, আমাকে যখন নেবো তখন সিরিয়ালি নিয়ে যাবো। হ্যাঁ হুম In all the cases, file affidavits. Be ready with the affidavits if have been amicably settled, and also find out in all the provisions of law whether amicable settlement can be, order can be passed. Satta matter, give a list of that.
Judgment on that.
Whether it can be amicably settled between the parties, the nature of offense.
Yes, Lord.
You just find out in all the 7, all the allegations which has been labeled against by and between the parties, whether it can be amicably settled
Lordship.
under the provisions of law.
Joint agreement. Lordship. I'll come with the.
Satu, give, Mr. Paul, give the list of the items.
Two matters are appearing, two which are not appear, I'll provide the number.
Friday the equivalent, you know.
Friday এর মধ্যে হবে? এই Friday এর মধ্যে মানে by this Friday মানে?
This Friday?
When আমাদের returnable date মানে?
Friday, day after tomorrow.
We have to
Day after tomorrow will be.
prepare the
For preparation of.
any day next week মানে?
Then Monday?
Tuesday মানে?
Or Monday for the Monday thing. For any reason Monday যদি না হয় তাহলে do Monday.
Oh. Number 2.
151.
Yesterday's matter is taken up. Yesterday's matter, my lord.
We'll proceed.
Table warrant was issued without issuing the summons. Lord, I have explained to my client, your lordship's view, my lord, he is preparing to surrender. My lord, I am.
Learned advocate for this thing, withdraw this application.
Yes.
Mr. So-and-so learned advocate for the petitioner seeks to withdraw this application. In view of such submissions, the application being CRR 522 of 2025 is dismissed as withdrawn.
But state present may carry.
Yes.
I get 154.
Petitioner is a lady living in a different remote village of Shitol Kuchhi, and owner of a Tata dumper truck. Look, the same was purchased in January 2020. With the loan from Axis Bank, the petition since then the petitioner is paying EMI of rupees 62,000 per month. Thereafter, the petitioner went to the office of the opposite party number 2 after the expiry of 1 year to renew his license, to renew the insurance. Miller, the insurance, because after the expiry of 1 year, the insurance has already lapsed. Thereafter, in opposite party number 2, he claimed to be the agent of the Reliance Insurance Company Limited for the purpose of renewal of license to renewal of insurance policy went to the office of the opposite party number 2. The relying on the representation, the opposite party number 2 agreed the petitioner for first party insurance policy. Thereafter, the opposite party number 2 to call the Xerox copy of the relevant documents and agreed a sum of rupees 54,000 to be paid, which the petitioner paid through cash and online. Thereafter, the opposite party number 2 handed over the petitioner a Reliance General Insurance Policy, first party insurance policy, that is bumper to bumper insurance policy, valid from January 2025 to January 2026. Thereafter, the petitioner was given false hopes that the insurance policy was genuine and the petitioner will receive all the privileges as the first party insurer. Thereafter, what happened is subsequently the petitioner's vehicle met with an accident. The GD was lodged in the concerned police station. Thereafter, the petitioner's vehicle was taken to Tata showroom for repair works. From the Tata showroom,
the petitioner was surprised to learn that the insurance of the petitioner made by the opposite party number 2 was fake, counterfeit, and fabricated, and the petitioner will not be entitled to get the privileges as a first party insurer. The Tata showroom also handed another insurance policy of the same aforesaid vehicle with a different policy number, which is a third party insurance, which was valid from January 25 to 26. Below, that insurance policy was issued behind the back of the petitioner without the knowledge of the petitioner. Thereafter, finding out that no alternative, the petitioner went to Tata Motors Kuchbihar to get his vehicle repaired. Thereafter, petitioner was handed a final bill of about 5 lakhs, including parts and labor. Thereafter, and the petitioner also suffered a loss of 2 months since the vehicle was at the service center for repair, and the petitioner was paying EMI of rupees 62,000 because the loan was because the vehicle was purchased with the loan from Axis Bank. So thereafter, the petitioner number 2, with a malignant intention, purposely hashed up with the insurance company as well as the Tata showroom, Tata service center, and cheated the petitioner. Immediately, the petitioner lodged a complaint before the Kotwali police station on June 2025. Thereafter, copy was also forwarded to the superintendent of police, Kuchbihar. No steps were taken by the police. Thereafter, the petitioner filed a miss case under section 175(3) of the BNS, praying for lodging FIR against the opposite party number 2 and directing the police authorities to take cognizance and to make necessary investigation. The trial judge rejected the miss case on the ground that malignant intention of the fraudulent, no malignant intention or fraudulent activity of the opposite party of number 2 was found. And the learned trial judge was also pleased to observe that the dispute was purely civil in nature. Lord, kindly takes up the order dated 10th September 2025, first page of the certified copy. Lord, the matter is technical in nature, governed by the insurance policy rules and IRDA regulations. The learned trial judge mechanically passed an order stating that the matter is technical in nature and is governed by which rules under the IRDA. Nothing has been stated. No investigation was conducted. Thereafter, without applying his mark, the learned trial judge also stated that no malignant intention of the opposite party number 2. How malignant intention? The opposite party number 2 has already cheated he has taken a sum of rupees 54,000, which I have the bank receipts. The fund has been paid online. Thereafter, the petitioner paid him the money. He has handed over an insurance premium. That is, I have annexed the insurance premium, valid from January 2025 to 2026, 1 year, with the policy number. That insurance document is at annexed in certified copy. Thereafter, the
Give notice. Give a notice to the state. What is 175(3)?
yes, that is 126 of
21, paragraph 4 দেখে নেবেন number. The this was taken to a garage, no? The said vehicle was what, for servicing?
For detailed what?
The said vehicle was the said vehicle, since met with an accident, was taken to the Tata showroom Kuchbihar. Stop. After repair, when the claim for disbursement was placed before the insurance company, it was detected that the insurance policy which was handed over by opposite party number 2 was fake. The petitioner, for issuance of such insurance policy, has made a considerable payment of 486,922 to opposite party number 2.
To the Tata showroom at page 20.
No. For having the insurance policy, what did you make payment to opposite party number 2? We have 53468.
Yes. It's
53468.
The table I have given at.
On such allegation, the petitioner
Kept and on.
filed an application under 173(3) of the BNSS. However, the same has been rejected on technical ground. Without considering the facts of the case. In view of such submissions, petitioner is directed to serve notice upon the opposite party number 1, State of West Bengal, through the Office of Additional Public Prosecutor, High Court, Calcutta, and to register speed post acknowledgement to opposite party number 2 and file affidavit of service on the return mobility. Please this matter before the next available circuit bench under the heading contested application. Petitioner this. Along with a copy of the complaint as a revisional application and annexures. Next. Why? What is this case? Delay. You are of delay. You are the complainant. In GR case 5334 of 2022, you are the complainant. PB1. Now, first. Within.
My lord, 157, I am for the petitioner. My lord, this is an application for expedite hearing of GR case number 5334 of 2022 pending before 4th Court of Judicial Magistrate at Siliguri. Kindly consider the order sheet which is at page
157, you join afterwards. We are in 158 now. 158, what is the prayer? Change currently pending. So causes to why. Was. What for? Any. He was not today. Alkas. But কি বলছে দেখি 157 if he joined.
157. My lord, 157, I am for the petitioner. This is an application for expedite hearing of GR case number 5334 of 2022 pending before 4th Court of Judicial Magistrate at Siliguri. My lord, am I audible?
Yes. It was very
My lord, kindly consider that charge sheet was framed on 8/9/2023 of this matter. The CSW1 started on 5th January 2024, and the CSW1 was closed on 23/10/2024. Since then, the matter has not proceeded. It is because either of the accused persons are not coming or any other reason. And this is a complaint filed by a destituted lady along with her destituted daughter who have been thrown out of the house.
If you summons. PSW. Awesome. Leonard. Yes, Mr. Chakravarti. This is an application seeking for this is an application seeking for a direction for expeditious disposal of GR case number 5334 of 2022 pending before the Learned Judicial Magistrate 4th Court Siliguri. Mr. Learned advocate for the petitioner submits that the charges have been framed on 8 September 2023 and thereafter only PW1, that is the petitioner hearing, has been examined. It seeks for expeditious disposal of the case. Mr. Niloy Chakraborty, an additional public prosecutor who usually appears on behalf of the state, is requested to appear in this matter. Let the appearance of Mr. Chakraborty, learned APP, be regularized. Learned advocate for the petitioner is directed to serve copy of the application along with its annexure to Mr. Chakraborty. Upon going through the orders annexed, it is found that charges have been framed on 8 September 2023. Until date, only one witness have been examined. In view of the above, the revisional application being CRR 531 of 2025 disposed of directly in trial court to dispose of the case as expeditiously as possible without granting unnecessary adjournments to either of the parties.
Deeply obliged, my lord.
You get this unfortunate lady, the petitioner, don't put this on our court. Against the executive order, dated 4/11/2025 passed by landed ACC in Shiliguri, in which this petitioner has lodged a complaint to the officer in charge of Matigara Police Station, Lordship.
The order is passed by additional sessions judge.
Additional Chief Judicial Magistrate Shiliguri, ACC. One application has been filed by the petitioner under section 156 subsection 3 of CRPC previously, now it is 173. Praying for sending the complaint to the officer in charge Matigara Police Station for investigation her complaint. Lordship,
Now, what is the allegation? Case 30 of 2025, which is the complaint? This one. 30. Miss petition 30.
this petition is the application, Lordship, the complaint, detailed complaint and comment.
Forty-six. Is 45.
45 is the comment. Lordship, thing is that the husband of the petitioner, they entered into the marriage on 1/5/2019. Out of that wedlock, one son was born on 8/5/2020. The husband of the petitioner was the habitual drunkard, and ultimately he was brought to the rehabilitation center for his recovery. But before recovery, he has been taken back by the mother-in-law and the sister-in-law of the petitioner from the rehabilitation center by giving the undertaking, punishing the bond. Thereafter, the father-in-law of the petitioner, he left a piece of land measuring about 15 kathas And being the joint owners, they somehow managed to get the signature of the deceased husband of the petitioner in a gift deed.
Her husband has died.
Died. After completion of the gift deed, he died. And that gift deed has been prepared and manufactured by the way of the fraud factory. Lordship, I am referring one document. Please see the page number 44, that is the type copy 44A. The 44 original document is the prescription of the doctor who has given just before the death of that husband. See, certified that Obijit Kundu, this is the petitioner, husband of the petitioner, 34 years, male son of late Balaram Kundu, resident of 3 number Satyam Ghosh Road, Post Office, Kodamtala, K. Patigara district, Darjeeling, was a physically patient, psychiatric patient with drug addiction, Raja addiction, alcohol addiction. He was under treatment at All India Institute of Medical Science, Kalani. He died of severe chest pain and cardiac respiratory at his residence at on 12/12/2024, 7 p. So this was the certificate, and the gift deed was registered on page number 41 on 25/11/2024.
Yes.
Thereafter, one specific complaint has been lodged to the concerned police station, and on refusal, the complaint has been made to the commissioner of police. Thereafter, invoke the jurisdiction of the court by filing that application, praying for sending the culprits to the concerned police station for investigating that serious allegation. And in the meantime, she has been.
This person appeared before the registrar.
Who, Lordship?
The husband of the complainant.
Somehow it has been.
No, what? How can? There is a signature, there is photograph. No.
Serious allegation of that.
How
And
can?
because at that time, you are not in a position to put his signature.
That is what you are saying, no?
Whatever, the allegation, serious allegation, is that it should be scrutinized.
Your main allegation is that the registration is a fake registration. The person was not present. It is found that the
Not
person has
that,
present.
it's continuously assaulted and the physically.
That is something to be decided. That allegation is not there. Your main allegation is against this give deed. 13/11/2024. He was present. His photograph is here. He has put his signature. Then what is the infirmity in the order?
Just see the signature is paired in the purported gift deed, Lordship. When he was a psychiatric patient, he was not in a position to give the consent at least for preparation of that gift deed. However, the matter should be investigated at least. And not only that, she has been continuously subjected to the cruelty of physical and mental torture. She has been tried to oust from the matrimonial house.
This gift deed has to be challenged. This is what your contention is, it's plainly a civil litigation where the challenge to the gift deed can be made for declaration of the void. Now you take the plea. What are the allegations? What are the allegations?
She has been continuously assaulted by the in-laws for ousting the petitioner from the matrimonial house.
Where is your complaint?
Lordship, page number 24. Annexer P4.
Where is the injury report? Injury report.
Lordship, page number 23.
This is 25th April.
First complaint before the inspector in charge, Swatigara Police Station, page number 27 and 28 is the typed copy, Lordship. It is written in Bengali. 27, 28 is the typed copy.
Your possession has been secured in the mispetition.
By the DVI.
Mhm.
In spite of that restraining order, they already transferred the property in the name of the other person. However,
Have you filed any
I will
civil
take
suit?
care of that thing before that.
Have you filed any
court
civil
order.
suit?
Regarding this?
Any civil suit filed by your client?
No, no.
What is to be investigated now? Challenge the gift deed before the civil court.
But regarding my torture,
Your possession, you say that they are threatening you to quit and vacate the premises.
yes, Lord.
Then your possession has been, they have been restrained from dispossessing the petitioner.
Yes, Lord.
So you have been favored with an order by the.
I didn't come against the DV Act order. Only the thing that regarding the investigation which I prayed before the appropriate court of law, that has been rejected.
What is to be investigated?
Submission.
What is to be investigated? That the gift deed is fake?
No, that is the amendment.
If there is assault and there is violation of the order passed by in the DV Act, there the court is there. What is the step? What are the steps have been taken before the court taking up the Domestic Violence Act case?
That is the different court of law.
What did you state before the court that there is a violation of the order of the court?
That before lodging the complaint, that case has been initiated. After lodging the complaint, that case has been initiated.
When was the order passed?
The order is not annexed there.
You are favored with the order. Your possession in respect of the shared household has been protected by the court. You say there is a violation, there is a constant threatening upon you that you quit and vacate the premises. that has been protected.
Lordship,
Now,
give-
what step have you taken?
Give me a date, I will file a supplementary affidavit with the order as passed by the company.
What is section 31 of the Protection of Domestic Violence Act? Section 31.
Penal proceeding.
See. Then advocate for the petition. Find out what are the steps taken, because court has also observed that she is entitled to take recourse to section 31. That tantamounts that you have not taken any steps when your protection, the possession was protected by the court. Now, if there is a challenge, this has to be declared as null and void. There are other provisions of law.
Yes, Lordship.
Then
I should confine myself in
the
respect of
if
only
deed is executed before the registrar. There is a photograph which is not a passport size photograph. This is a photograph taken in presence of the registrar in the office of the registrar.
Yes, Lordship.
The person, the husband of the
That is
petitioner
good.
has put
How
his
it has been-
signature.
How it has been procured?
No, that is your
The
contention. Your
person-
contention might be that he has not appeared,
Person is not able to.
but
move
that
from the
evidence has to
place.
be taken by the civil court. On the prayer, learned advocate seeks leave to file supplementary affidavit. Let such supplementary affidavit be filed within a week. Is this matter? After a week. See that you also know that that is the recourse left to the petitioner is challenge the gift deed before the civil court. So that is the only option out.
Lord.
এক সপ্তাহ পরে রাখুন করবে না। Next.
160. My lord, in item number 160 and 161, I am appearing on behalf of the petitioner. These are two similar matters, my lord. If my lord kindly takes up the matters together, my lord, you can hear from me.
What is the matter?
It's for transfer, my lord, transfer of two separate proceedings going on in Barakpur Court to Alipurduar Court. My lord, I am on behalf of the wife, that is the petitioner in both the proceedings. My lord. Well, my husband is the practicing advocate at the Barakpur Court itself, my lord.
Oh.
And he is continuously assaulting and assaulting me, threatening me, and as well as my lawyer not to attend the court, not to continue the proceedings, my lord. In item number 161 plus here 537, I have annexed one complaint of my lawyer. Page 21, Annexure 50, where my conducting advocate has filed this complaint before the Secretary of the Bar Association of Barakpur Association, Barakpur Court, where he has stated that he has been threatened and assaulted by my husband and his associate lawyers. But I mean, immense threat, my lords. That is why this petition. And I am praying for transfer of the two proceedings to the Alipurduar, which is my parental home and my permanent home now. I live with my parents there, or any other court as my lord deems fit.
Advocate for the service has been affected. No.
No, my lord.
So give a notice. This is an application seeking for transfer of
My lord,
Miss case number. Yes.
one more intelligence. I am praying for stay in both the proceedings, my
No.
lord. Otherwise,
Why it
my-
will be stayed?
with my lord, for final hearing of the mentality petition.
You know? 149 of 2022 pending before learned judicial magistrate 5th court Barakpur. To which court?
Alipurduar Court, my lords.
To the Alipur, to the court of Alipurduar is chief judicial magistrate.
Yes, my lord. No, Alipurduar, my lord. It's in Alipurduar, not Alipur, Kolkata, Alipur. It's
Alipurduar, you have a chief judicial magistrate.
Chief judicial. Yes, yes. Yes, yes, my lord. Separate.
To the jurisdiction of Alipurduar court. Now, the advocate for the petitioner submits that there is trade upon the petitioner in attending the court at Barrackpur. Learned advocate for the petition directed to serve. State is a party.
State is not a party. Only the husband responsible.
This is Miss case upon the opposite party. Through racial speed with acknowledged union, file affidavit of service on the returnable date. Place this matter before the next available circuit bench.
I'm grateful.
61.
61 is a similar matter.
61 এর এটা আলাদা হবে না 61 টা 61 এর জিআর কেস মনে হচ্ছে
Case number is different.
complaint case
No, that is a thing. File under 156 cumulus. Yes.
one 125
One, yes, madam. The 161 is 125 CRPC and the first one was domestic violence. 12.
same order the case number টা চেঞ্জ হয়ে যাবে প্লিজ বাবু কেস নাম্বারটা শুধু পাল্টে দিন এর কেস নাম্বার হচ্ছে M case number 551 of 2022 both are before the 5th James Judicial Magistrates Court
Judicial magistrate. Both,
5th court
both means. Both is in bad court.
5th court
Fifth court, madam.
next slide লিখে দাও
162.
এদিকে নট টুডে চলে যাবো non appears on এটা কি ছিল? Washing. None appears on behalf of the petitioner. For ends of justice, the matter is adjourned. This matter.
My lord. Ask about matter, I could, put number 4, my lord, that's the next. My lord, I have not received the copy of the plan from the constitution office.
Where is Mr. Saha? You have not served the copy?
Yes, sir, the office has not issued the.
Or received that office?
Yeah.
Tomorrow?
Yeah, tomorrow. This, last year I was waiting for the government. So we can therefore not.
Tomorrow?
If I can get the copy.
No, not if. Get the copy so that the matter can be heard because yesterday. কালকে এটা নট টুডে করে দিন ক্রিমিনাল অ্যাপিলটা নেক্সট উইকে রেখে দিন টুমরো আর কোনটা পাস ওভার আছে মোশনে 146 হয়ে গেল কালকে আসছে হুম
163.
হুম notice affidavit of service this is GR case
Yes.
The walking of the number 392 of 2023.
Sole accused. Sole accused.
The principle of law, which I forward for the second subsequent FIR, discloses no cause of action or no offense is made out of subsequent effect, it should be false. Now, Lakshmi kindly turns to page number 30.
Guru Nihal Singh, देखो.
Page number
Page number
30. Page number 19, annexure A. This is the first FIR that was lodged against you. Particular Mr. 45 of 2019. Long FIR, 8 pages FIR, the allegation against me is that I involved myself in manufacturing fake deeds, and on the basis of the fake deeds, I have tried to encroach upon escort and take possession of the landed property of the company stream. The FIR was lost under sections 465, 467, 468, 471, 420, 120B of the Indian Penal Code.
The
Yes.
complainant is one of the purchaser. Complainant is a purchaser.
No.
How?
The owner of the.
Oh, his land has been
He's
transferred by your client by way of a
That is on the basis of.
forged document.
First FIR was logged in the year 2019. This is annexure A. Now,
45.
Long FIR, each pages FIR. Can you take the first page number 20 of the complaint? I, Guru Prakash Singh, son of late Thakur Gurumukh Singh, resident of Kachan, was the erstwhile recorded owner and possession of 3% of lands measuring 23.23 acres. Recorded in RS Petition number 551, according to RS Petition number 179, 187, thereafter 190, 197, 190, 2002. These are the plots of these plots of where I am trying to the next FIR. The police has filed a charge sheet in this matter. Charge sheet is at page 27. Under the same sections, 465, 467, 468, 471, 420, 120B, to charge sheet. Now, the kind turns to page annexure C, page number 34. This is the second FIR lost by his relative, the son of the erstwhile complainant, Avinash Singh, son of Guru Prakash Singh, page number 34. Complaint is at page number 35.
Yes.
I, Avinash Singh, son of the Guru Prakash Singh, after 2019 and this 2021, after 2 years, he is complaining. I, Avinash Singh, son of the Guru Prakash Singh, resident of Calcutta area, beg to inform you that we have land measuring same 23.23 acres situated in Moja, Calcutta, and that plot number, same plot of 3036, 492, 493, 495, 715, 719, and 732. Police station Matkara, some men named Rahul Parwan, Bindu Singh, Raju Saibo. Number 5 is my name, Sidar Shah, Alvari. Started to beat on my lands with ATV. Then I tried to stop them. stop them, they manhandled me and hit me on my face. Due to which I am not able to hear right now. The which line was already in dispute because the ticket in the documents. Now, Lordship, I subsequently I came for approach this honorable High Court for quashing of this second FIR. The order is at page 36, annexure D.
Or 82. What was paid in CRR 25 or 2022?
Yes, here are good payments. This second FIR, 2021, I come for quashing of this FIR because this FIR also discloses same thing.
No, what was paid in 25, 2022?
Quashing of FIR number
2.
Yes, second FIR number 141.
Subsequent one.
Subsequent one.
So court has clarified that situation.
Yes.
It has stated that if there are other allegations that can be investigated and charge sheet can be filed, but not in respect of allegations relating to forgery. So subsequent, it does not that the subsequent one is same as that was the earlier one. Court has clarified that situation. So
Page number 45.
45.
Again, after another one more year, another FIR. By good leadership, they are relative of the first FIR and second FIR. What they have stated in this page 46. Respected sir, I Gurniyal Singh, son of Fred Gurmukh Singh, resident of sir. I beg to inform you that on 25/5/2023 at about 1 p.m. to myself along Avinash Singh, Parameshwar Singh as well as police team from Matikara visited my land measuring same 23.23 acres situated at Moja, Jalpaiguri and found that some local young men people assembled at my land. I asked them why are you working or digging at my land? I demanded them to produce any valid documents in respect of this, but they did not produce any valid documents in respect of the land and treat us very rudely. They start heated argument and and there are very few instances they tried to manhandle us due to present manhandle us, but due to presence of police officer, they control. They stated that they are staff of the land of Rahul Burman, Shambhu Burman and Vijay Shah, and they threaten our life. Rahul Burman and Vijay Shah both made fake documents in respect of my land and selling it to different people to understand. Previously, my family members already filed many cases like this. The reference 45 of 19, 14 of 19, 19 of 22. I request you to stay together. On this, again another FIR. Same thing. This FIR does not discuss anything new episodes, no new story, no new cause of action. That was I come for you for watching of this FIR. What this
This
FIR,
one.
This one.
The last one.
This last.
Yes.
I will taking to clarify that success FIRs are not common. If it is on the same language. Here, three FIRs. If the allegations are distinct, the first information can be logged and can be served. But in spite of that, I have not having the case diary of three successive FIRs. The case diary is required.
Oh, hi, sir. Produce the case diary. There was a direction. State is directed to produce the case diary. If it is not produced, how this application will be hard under contested application?
Kindly allow me, please, fix the matter on Monday, I will produce.
On Friday, you produce the case diary on Friday. He has made his submissions. You will make your submission on Friday.
Instead of Monday, I will bring Tuesday or something.
Then it will go to the next circuit.
I am surprised. Nothing. This FIR, nothing. When they were.
One day of addition is vital. No, only 2 weeks are there. Since you have made yourself, let it come up on Monday under contested hearing.
There. Person, honest, my friends were. To be very honest.
Then it is a real problem. You have to go. Twist is it, huh? Twist. Heard Mr. Devorshi Dhar, an advocate for the petitioner. He submits that the de facto complainant and his relatives are filing complaints before the police authorities, before the police jurisdictional police station, one after the other, with the similar allegation, which has prompted the petitioner to approach this court for quashing of the subsequent FIR being Matigoda Police Station case number 392 of 2020. This is 2024.
25th, May 25th.
23, women. 23. Learned advocate Mr. Subhashis Mishra, learned advocate for the state, seeks accommodation to produce the case diary. List this matter on Tuesday.
The accusation of verifiers of options. If like to. I need to. But I could be all the things that because it feels such a verifier.
The case diaries of all the proceedings be produced. Stated. State is diary produce the case diaries of all the proceedings.
164.
Supplementary. My lord, this is a case where the petitioner was directed to file a supplementary affidavit regarding the court order in which the vehicle was released, Lordship. I think they have already filed it. I don't know. They have to give a copy to the state because in this case, my lord, they have filed for quashing of the application under 482, and the person who has been arrested, Lordship, he was convicted under he was charged under the NDBS Act, and he is the owner of the vehicle, and his name, yes, sir.
পুরিত বাবু আগেরটা ওই ওপরের অ্যাফিডেভিট অফ সার্ভিসটা ফাইল বছর লিখে দিন তো।
The crux of the prosecution case is that, my lord, the present petitioner, my lord, he sold out the vehicle long back in the year 2016.
Where is the supplementary affidavit?
Satyajit.
For short password,
But it can be kept today because we didn't in the case diary also, but in the case diary, his name did not transpire. Only from the co-accused statement that he has sold the vehicle, that is there in the case diary. So kindly fix it tomorrow. Lordship will do the matter tomorrow.
Not today.
তুমি কালকে নিয়ে আসো ওইটা। ওইটা আসবে, সত্যজিৎ করবে। সত্যজিৎ।
Item number 165, I am for the petitioner.
I have got the de facto complaint appointed by legal aid.
During the pendency of the CRRMB, charge sheet has been filed by the police. So I want to bring the charge sheet to the record. Kindly give me liberty to file a supplementary affidavit.
More in favor of performing engaged in favor of Adhir Chandra Sarkar is the in the
165 crore.
uh,
How about the statement? Constitutively.
CRR 387 of 2024.
But the charge sheet has been filed, in the meantime, I want to bring it on the record by way of a supplementary evidence. Kindly direction may be given for filing supplementary.
What is the fact of the case?
Copy may be served.
What is the fact of the case?
But the facts of the case is that. The case has been initiated on legal complaint of the impact of complainant, opposite party number 2. Now, on the basis of the same, case has been started under section. Under section 69 of PNS. Sorry, 69. What was it?
69.
There are two FIRs. Two FIRs.
There are two FIRs. One is lodged against another person. And one is against me. Both the facts are same. Because how can the de facto complainant be with the same person?
বলুন না আমি একটু এখানে এত কথা বলে হবে না নাকি I request all the learned advocates, please don't talk when the matters are being taken up. Yes. There are two FIRs of the similar allegation, one against the petitioner, other against the other.
It's a third person. But in both the cases, Lordship, the allegations are the same. How can there be a promise of marriage in both with both the parties?
Okay.
That's why there is a stay also. The Honorable Justice Subhendu Sumanto on 3/10/2024 has granted a stay.
You will file your charge sheet of which case? Charge sheet you will be filing by way of a supplementary in respect of which case?
The Siliguri case number 93 of 2020.
93. 485. This is 485.
okay.
This is 485. First case is 485. Sure.
No.
93, who is the accused? Petitioner.
Then.
Petitioner 376 allegations. Maybe there is a two case, but it is not a case to the entire proceeding will be. So promise to marriage can be, you can enjoy both promise to marriage with both the parties. It will be decided by wife both the parties. You are the same party. No, absolutely no.
Where is the FIR?
Whatever the against that particular petitioner, he has to take the consequences. Maybe maybe another case may be there, but it doesn't mean the entire course goes to election.
In the end, charge sheet has been filed as per the law. So the prima facie case established.
Without evidence
No.
or sheet. At this juncture, this is not the fit case for.
So he only to this pair for question and fact.
Which is the first case against you? There is a complaint lodged by the de facto complainant. Which one is that?
That is page number 35. Lordship against the petitioner, this is the case, and annexure P2 is the case which is against another person which is known as Kalyana, which is Kalyana Adhikari.
Kalyana is defective.
Prodigal is also accused, the another case.
Another case,
Yes.
allegations are plainly.
So you will filing a copy of the charge sheet in which case?
93, Lordship.
93 is available in the case diary.
Like 90
So what is the use? What is the necessity of filing that? It is already present. Yes, Mr. Shah.
Lordship, actually, it was the impression that during pendency of my application, charge sheet has been submitted by the investigator. Then it is my duty to incorporate the charge sheet by way of the supplementary evidence. Give me just 2 days, I will bring. For the proper adjudication, it is very much required for bringing the same.
Charge sheet has been filed.
Yes,
Then.
I got the certificate copy.
Fair is the question of fair.
Lordship, my contention is when charge sheet has been filed.
Your contention is that the subsequent FIR has got no relevance so far as the present petition is concerned. Learned advocate for the petitioner seeks leave to file supplementary affidavit annexing the copy of the charge sheet. Let such supplementary affidavit be filed by the returnable day. Please this matter on Friday under the same heading.
State obligation. One 66, I don't know one. Over the time, we'll appear on shoulder. It's a reform that.
What is the stage of the proceeding? Charges have been framed. Charges framed.
I don't have the.
On the prayer of learned advocate for the petitioner. Service who is for the state? They have not served. Also find that what is service was effected upon the authority. Find out service has been affected upon the state.
Maybe there is a endorsement from received, maybe.
This was filed before the principal bench.
Oh, that is the difficult. Yes, the lawsuit, when I was instructed by the appeal on it not to do. Follow up করতে হবে না তোমার কি হচ্ছে না
কালকে আসুক উঠে আসছে not today.
Regarding 167, I beg to appear for the petition.
I'm for the private respondent, Lordship. Praying for 2-day accommodation. Kindly fix this one on Friday, Lordship.
This is my affidavit of service. Yeah, below. Milord, initially the case was registered.
Wait. Yes.
Initially the case was registered under section 505 surplus 2 of the NAV. If your lordship would kindly comes to page number 12, your lordship will find the copy of the FIR. Lord, one of the crux of the FIR, Lord, which is the company happens to be a legal practitioner of Darjeeling Court. He came across a particular post in Facebook. That post showed some video footage of Thailand or some place portraying that particular video to be a red light area of Darjeeling. Now, that is the allegation. He came across that post and he informed that to the cyber police station of Darjeeling. Now, my complicity in the instant case is that particular post was made by some other person, namely Milord Kameshwar Roy.
এটা কত আইটেম দিয়েছো?
167. 167. But the matter is
পার্থ দাস,
yes, sir.
নট শেফালি রায়। এটা কি দিয়েছো? পার্টির নামটা 2024 দিতে হবে তো, ইয়ারটা ভুল আছে না? ইয়ার ইজ 495 2024।
Yes.
এটা দিয়ে দিন, কালকে মেন ফাইলটা নিয়ে আসুন। 2025 file has come, so tomorrow I'll take it up.
Lordship, kindly take it this matter Friday, Lordship. Friday, Lordship.
ফ্রাইডেতে লিস্ট করে দাও নাম্বারটা নিয়ে। 2020 নাম্বারটা তো ঠিকই আছে, এখানে তো ঠিক আছে, রেকর্ডটা ভুল এসছে। নেক্সট।
168.
Lordship, I am for the respondent to wife, Lordship. So, affidavit in opposition, Lordship, file with the
What is this case?
Under section 498 A, Lordship, and I am for the husband.
Affidavit in opposition filed on behalf of the opposite party number 2 is taken on record. Copy served.
Copy not.
Learned advocate for the petitioner seeks accommodation to file affidavit in reply to the affidavit in opposition filed on behalf of opposite party number 2. Let such affidavit in reply be filed. How many days, madam? Within a period of 2 weeks from date. List this matter before the next available circuit bench. Yeah. Affidavit of service of the hearing filed on behalf of the petitioner is taken on record.
After the step. I'm holding the CD, my lord. I call CD. You are for the defect.
You put him in over. Who is the opposite party number 3?
Lordship, I am opposite party number 2, Lordship. De facto.
2. 2 or 3?
2, Lord.
De facto complainant.
What de facto complainant?
Lordship, de facto complaint.
De facto complainant Rajdeep Das.
Lordship.
But where is your affidavit in opposition you filed?
Lordship, later on, I have submitted that I will continue without the affidavit in opposition.
You have submitted?
Lordship.
Okay. This case ago. What is this case?
Lordship, there is a stay continuing in this case.
Stay has expired. 26 September 2025. It was extended for till 28th October. 28th October to over होएगा.
In the meanwhile, they have filed an application for restoration matter.
Fine.
At 3:25. 31st.
Mr.
they have filed.
Rupayon Dev is a practicing advocate of Jalpaiguri. Priya Nandi,
No, Lordship.
Rishi Raj Gupta.
It means Jalpaiguri here and this they have mentioned. Actually, Lordship, we are from Shiliguri, we had been for each and every Shiliguri. So I don't know entire member of the bar.
Sandeep Guho Rai.
Sudip Puhara, my lord.
Sandeep Guho Rai.
Sandeep Guho Rai.
ডেকে ডেকে মামলা করবে?
Lordship, this is the case.
You are saying that there is an application, but there is no headache of the petitioner to move that application for extension.
Lordship, let it go out of list, Lordship.
Lordship, and I also return back the CD. As because when they have already, initially they have informed the trial court that the matter is pending before the Honorable High Court. Naturally, trial court cannot look into the matter. And in the meanwhile, they did not bother to continue stay or appear before your Lordship. But the assumption is still the stay is granting, Lordship. That's why it is a.
What is the fact? Why this application has been filed?
Lordship, their allegation is that they have spent money amounting to 60 lakhs for installation of gym business, and subsequently he is ousted from that business. And then,
No, outside. Lordship, subsequently he did not deliver the goods and also is not returning the money. And when the police has approached him, the shop was not there, Lordship. He has closed the shop and has fled away.
And they have separated the foods, and there is a beef voucher, everything is CDO. Misappropriate.
Charge sheet has been submitted.
Oh my
মুশকিলের কথা। Oh, none appears on behalf of the petitioner. Opposite party number. State is opposite party number 1 and opposite party number 3 are represented.
Opposite party number 2 is marriage.
3.
2. Opposite party number 2 is the de facto complainant.
The court can only close. এত জোরে বলছে যে ভুল করলো go through the petition. Go through the petition. Opposite party number 3 de facto complainant. 3, huh? Is represented. Is this matter before the next available circuit? সিডিটা দিয়ে দিন
Lordship, in item number 170, my lord, I appear for the petitioner, my lord. My lord, this is my application for quashing of proceedings, my lord, and initially, my lord, on 28th of January, an interim order was, my lord, passed by your lordship, my lord, and it has been extended from time to time. My lord, the same is due to expire on 30th of November, my lord, and we have filed an application for the extension of the interim order, and that is due to appear on Monday, my lord. If your lordship fixes the CRAN application and this main application, my lord, on Monday, then your lordship could hear it, and my lord, Mr. Ayan Bhattacharya is leading us in this matter, so he would be Mr. Ayan Bhattacharya. He is leading us, my lord, in this matter, so he would do this physically, my lord, if your lordship fixes it on Monday, my lord.
My lord, we are for the respondent, my lord, in NCB. If your lordship fix it on Monday, we have no problem, my lord. We are ready for hearing, my lord.
The interim order will expire on which date?
On 30th of November, my lord.
Monday কত তারিখ? On the prayer of learned advocate for the petition list this matter on 24th.
Along with the CRAN application, my lord.
Now it will appear along with the grant type economy. 7, CRAN 7.
Yes, my lord, CRAN 7.
CRAN 7. Will appear. It indicate করে দেবেন CRAN 7.
My lord, my appearance may be noted, my lord.
Oh, it will appear করছে CRANটা ঠিকই তো আছে. It will appear. Yes.
My appearance, my lord.
Yes. Your appearance, no, Mr. Sudeep Pod.
Published, lordship.
The Pod for NCV.
Being led by Mr. Surya, he's on his leg in court one. They want the direction to file supplementary affidavit, annexing the charge sheet and additional documents. As I have affirmed that. If this matter will be taken up tomorrow, I file the supplementary affidavit.
Who is for the state? This is for quashing?
Washing of
171.
Let it be taken up tomorrow, my lord. I'll file the supplementary affidavit. It has been affirmed.
The case diary has come.
No, case diary was not available, my lord, on the last 2 occasions.
No. Today it is available.
Is in code number 4.
And the submission of the state was that as the case relates to the year 2000, so the CD was not available.
Of 2000?
It was not found. Case diary was not found.
So you will be filing the copy of the charge sheet along with.
Charge sheet along with all the additional documents. It has been found, my lords.
Oh. Mr. So-and-so, learned advocate for the petitioner, seeks accommodation to file supplementary affidavit in terms of order dated 10th September 2025. So, state is not represented, unrepresented.
Let it be fixed tomorrow, my lords.
It has already been affirmed. The supplementary affidavit is with me. I
Yes, yes.
submit tomorrow, madam, in court.
কালকে কি অবস্থা রাখবো No, day after tomorrow. This was heard by the earlier bench.
Ultimately, my lord, when CD could not be traced out, my lord, the petitioner was directed to file the supplementary affidavit and it's in the documents.
Friday.
Therefore, let me ask you a question.
175. 172.
What is this case? Charge sheet. Mr. Chakraborty.
The report has to be called for. Why not ask for the stage status of
The case diary is not with you.
No.
In service of private responsibility, incomplete.
Is
None appears on behalf of the petitioner.
Case of 2008, charge sheet was filed in 2007. Probably parties are not interested to move the revision application. I don't know, maybe.
They are not interested, they can come up to the court and say that they are not interested. It will be withdrawn. This is a case for 493, 376.
My words.
Service is also not complete. None appears on behalf of the petitioner nor any affidavit of service filed. Next week. With this matter, next Wednesday. Next Wednesday, you can file the report. State is directed to file a status report. And also produce the case diary. It is there.
It is there, it's a old case, and now it's before the trial court, India trial
Okay.
court, my lord.
Directed to file a detailed status report on the returnable date, Wednesday. Taraf.
Yes, Lordship. That's it.
Pretty clear about it, sir. কি হয়েছে? তুই যা না, তুই ওকে মুভ করতে পারেনি, তুই এখানে সবাই কি করছিস? এখন খাচ্ছিস? তুই যাও করে ছেলেদের ভাই দায়িত্ব জ্ঞান নাই কিছু, নিজের মামলাটা সকাল থেকে পড়ে থাকবে।
কখন মারলাম?
Okay, but status report and
You are there.
was to be called.
For the petitioner, status report has only. Yeah.
State. Case diary is there.
No.
Why?
They are called for, but they are not received it. Whether the articles which were seized are green firecrackers or not, to accepted that, and what was the status report? What did the IO give in the charge sheet?
It is. Learned advocate for the state seeks to file a status report. Accordingly, state is directed to produce the case diary along with the detailed status report on the returnable date. Wednesday.
Returnable date. Next week.
Wednesday, next.
26 तारीख. Gracias.
174.
May I please, Your Lordship? So item number 174 appear for the petitioner. This matter, there was a stay. Your Lordship, this is an FIR of 2007 under 498A. After 19 January 2021, the matter has not proceeded at all. It is unnecessarily pending for the last 18 years. So matter has been stayed. The state was asked to file a report, status report, with regard to the development of the case. This report was called for on 31st of July 2021. Thereafter, the matter appeared on 21st of August 2025. They have sought for an extension. Till date, the status report has not been filed, and unnecessarily I am being harassed. I have to appear before the court below.
Yes.
The charge status of the matter, as per my information,
Status report.
evidence of charge sheeted witnesses has been completed on December 2018. Then prosecution witness started. Now, from 19 January 2021, there has been no proceeding in the matter at all. The matter is unnecessarily getting adjourned, but I have to face this harassment.
What is the prayer for quashing?
Yes, Your Lordship, for quashing. Nothing in the case. Nothing has been found. There are no witnesses against me. The matter is unnecessarily being prolonged and delayed before the court.
How long is the interim order is extended till which period?
Last day of December, Your Lordship. Last day of December. It is there. Interim order is there.
Extended till the last day of December. When can you file the status report, Mr. Chakraborty?
Well, status report, it's true that status report was first asked on 21st of August. Last year on 21st of August, we have already communicated to our office. The office has also communicated, but we have not received the status report till now.
There, what status report they will give? From 19 January 2021, there has been no proceeding in the matter at all. There are no witnesses who is coming forward. For the proceeding.
Learned advocate for the state seeks accommodation to file status report in terms of the earlier order of this court dated 31st July 2025. Mr. Aurik Banerjee, learned advocate for the petitioners appearing through virtual mode, submits that since 19th January
19th January 2021. Yes.
19th January 2025, there is no development in the proceedings before the trial court.
2021.
21.
2021.
2021.
Yes.
Yeah, keep further. Coming week, Mr. Chakraborty. On Tuesday, on Tuesday.
Let this election be peremptory, because Your Lordship, on the next occasion I also appear, they will come and take them. Let this be peremptory.
Either the state will file a status report or you apprise the court what is the status with the certified copy of the orders of the trial court.
That I've annexed that to my petition.
Then what is the status now required?
Not required. The order was passed, Your Lordship. I have annexed all the order copies, which will show that from 19 January till date, nothing has proceeded in the matter. Your Lordship will
on Tuesday.
Grateful, Your
Okay, thank you.
Grateful, Your Lordship.
175.
My lord, item number 175, I do beg to appear for the petitioner, my lord.
Yes.
My lord, this order, my lord, assigning an order refusing my prayer for interim relief in an application under section 125, my lord, without considering that, my lord, no maintenance is being paid. There were earlier orders for payment of maintenance in proceeding under the Hindu Marriage Act and also in proceeding under the protection of women from domestic violence. Those orders were not being complied with. I am not being paid any maintenance. In spite of that, my lord, the learned judge in the court below, my lord, refused to, my lord, entertain my application for interim relief, holding that there were orders for maintenance without considering that no amount of maintenance is being paid.
I'm for the respondent, my lord. My lord, till that, my lord, copy not received, my lord.
Copy not received, affidavit of service has been filed.
That initially it was
Copy
served.
served, my lord, another advocate's chamber address, my lord. That's why petitioner not received yet.
For the petitioner.
My lord, in question to the earlier order passed by the other coordinate lordship, my lord, we have
the opposite party and fact.
we may, my
It is
lord.
not served upon the opposite party.
Yes, my lord. We will, my lord. If your lordship so direct, we can.
Respondent, my lord, did not receive yet, my lord. They served, my lord, another address, maybe, my lord.
Affidavit of service টা কোথায় আছে দেখুন তো? অনিরণ চক্রবর্তী. What is the name of the respondent is? Anirban.
Anirban Chakraborty.
Anirban. Anirban.
Chakraborty.
929. 929? Yes. Item has not been delivered. Sir, give a copy.
My lord, I will, my lord, by in course of by tomorrow, I will serve him a copy, my lord.
Learned advocate for the petitioner undertakes to serve a copy of this application upon the learned. What is your name?
Sudhindra Das.
You are representing the respondent?
Madam.
Learned advocate, Mr. Sudhindra Das, learned advocate for opposite party number. By tomorrow. By tomorrow, Mr.
My lord, my lord, my lord.
What's up, lord?
The opposite party, huh?
My lord, only shown one opposite.
Please this matter for Monday.
Wait for lord.
Oh, God. Only fair.
ছবি কেন আসছে না? আমার ছবি কেন?
Working on hardship and the entire regime. Many of the petitioners there are the in-laws of the complainant who have been unnecessarily dragged along and pulled in the instant case. Madam, kindly take the FIR first. That is case number 20. 19 is the FIR and 20 is the written complaint.
20.
The written complaint. Madam, while the application was heard earlier, madam, my entire case is whether an allegation which are general, vague and omnibus is liable to be cautioned. My entire case is that, madam, on basis of the entire complaint, it would be seen that the allegations made do not constitute the offences under section 498A, but are mere general and omnibus allegations against the husband and also the in-laws who are being roped in the dispute. But kindly see, if all the allegations that are being made is that there has been torture, there has been cruelty. It has not been substantiated that how the cruelty has happened, what was the role of the present petitioner in the commission of the offence, and whether that allegation amounts to 498A. That is very vital. Now, my lord, subsequent to this FIR, my lord, investigation was carried out in a very haphazard manner, my lord, and without conducting any independent inquiry, a charge sheet has been filed, which is summarily the basis of the complaint. Charges has been framed without ascertaining any single fact that would attribute to the case. The police was to investigate it independently to find out whether the allegations in the complaint are true or not. But my lord, kindly see in a mechanical manner the charge sheet has been filed. If my lord goes to the charge sheet, nothing has been filled by the police. Nothing, my lord. There is kindly see the seizure list except a marriage certificate, marriage card. Nothing has been seized to attribute any of the allegations. Statements of any independent witnesses not taken by the police, my lord. And considering all these, my lord, are stable branches. Now, my lord, there are several judgments that has been produced in time and again by the Honorable Supreme Court. One that would fall in these present facts, my lord, is concussion assault versus state of Bihar, my lord. Similarly placed allegations were there, my lord, with the Honorable Supreme Court had quashed the entire proceeding on the ground where the issues also were flipped. My lord,
Paragraph.
But firstly, to bring in resemblance, my lord, my lord, I would like to refer to paragraph number
All accused persons used to present
80 of the judgment first. Because the facts of the case, what were the allegations of that case is important.
Which page?
My lord, concussion assault versus state of Bihar, my lord. Paragraph number 80. Second last page, my lord. C07. Wherein the Honorable Supreme Court has drawn the inference of the facts. What was the allegation? May I read, my lord? Paragraph. Coming to the facts of the case, upon perusal of the contents of the FIR dated this, it revealed that general allegations are leveled against the appellant. The complainant alleged that all accused harassed her mentally and threatened her of terminating her pregnancy. Further, no specific and distinct allegations have been made against either of the appellants herein. None of the appellants have been attributed any specific role in furtherance of the general allegations made against them. Now, this simply leads to a situation where one fails to ascertain the role played by each accused in furtherance of the offence. The allegations, therefore, are general and omnibus and can at the best be said to have been made out on account of small schemerations. Insofar as the husband is concerned, now, even in that case, husband was not the petitioner before the Honorable Court. So the court has not considered the allegation that was made against the husband. Here the in-laws, that is the father-in-law and mother-in-law, had approached. Now, my lord, let us go into the discussion in the said judgment. My lord, kindly take issues involved that is discussed by the court in para number 10. That is at page 604. Para 10. Having perused the relevant facts and contention made by the appellants and respondents, in our considered opinion, the foremost issue which requires determination in the instant case is whether allegations made against the appellant in-law are in a nature of general omnibus allegations and therefore liable to be quashed, which is the facts in the present case. Now, my lord, what the Supreme Court has gone to is, before we delve into the greater detail of the nature of the allegations made, it becomes pertinent to mention the incorporation of section 498A, which was aimed at preventing cruelty committed upon a woman by her husband and her in-laws by facilitating rapid state intervention. However, it is equally true that in recent times, matrimonial litigation in the country has been increased significantly and there is a greater disaffection and result fiction surrounding the institution of marriage now more than ever. This has resulted in an increased tendency to employ provisions of 498A as instrument to settle personal scores against the husband and his relatives. Now, my lord, it has discussed the judgment of Rajesh Sharma versus State of UP, my lord. On the second page, my lord, relevant portion. It is matter of serious concern that large number of cases continue to be filed under 498A alleging harassment of married women. We have already referred to some of the statistics from the Crime Record Bureau. The court has earlier noticed that the fact that most of the complaints are filed in the heat of the moment over trivial issues. Many of such complaints are not bona fide. At the time of filing, implications, consequences are not visualized. As such, complaints leads to uncalled for harassment, not only to the accused but also to the complainant. Now, my lord, thereafter, my lord, a landmark judgment of Ernest Singh, my lord, wherein the uh, preliminary inquiry was suggested, my lord. This has been referred. The fact of section 498 is a cognizable and non-bailable offence has lent it a dubious place in pride amongst the provisions that are used as weapon rather than shield by disgruntled wives. The simplest way to harass is to get the husband and his relatives arrested under the provision in quite number of cases. Bedridden grandfathers, grandmothers, husbands, their sisters have been. Now, my lord, next para 14, my lord, there is this Priti Gupta, which is the leading judgment, my lord, of that para number 35. Para 14, sub para 35. The ultimate object of justice is to find out the truth and punish the guilty and protect the innocent. To find out the truth is a Herculean task in majority of the complaints. The tendency of implicating the husband and all his immediate relations is also not uncommon. At times, even after the conclusion of trial, it is difficult to ascertain the real truth. The courts have to be extremely careful and cautious in dealing with the complaints and must take pragmatic realities into consideration while dealing with matrimonial cases.
Yes.
The allegations are in the complaint are to be required to be scrutinized with great care and circumstance. Thereafter, my lord, several judgments again have been referred to, my lord. Thereafter, my lord, the Honorable Court has held that
Yes.
Para 70. Thereafter, facts were discussed. That the above mentioned decision clearly demonstrate that the court has at numerous instances expressed concern over misuse of section 498A. IPC and increased tendency of implicating relatives of the husband in the matrimonial dispute without analyzing the long-term ramification of a trial on the complaints as well as the accused. It is further manifest the said judgment that false implication by way of general omnibus allegation made in the course of matrimonial disputes, if left unchecked, would result in misuse in the process of law. Now, my lord, allegations, my lord, this is a very protective legislation that was incorporated. There was a purpose for this. Now, my lord, when we read into section 498A, my lord, every small skirmish that happens between a family member would not amount to constitutional offense under section 498A. Now, my lord, to constitute an offense under section 498A, my lord, the ingredients that are mentioned in the statute has to be fulfilled. The cruelty is defined under section 498A itself. It should be of such nature that the woman would be driven to commit suicide or be murdered. But my lord, kindly reads the plain and simple allegations that have been said that we have harassed her, we have alleged that we have tortured her. But what kind of torture? Nothing is there. It is all vague and my lord, all are false also. My lord. Now, after the lodging of this, my lord, one of the petitioners had approached this honorable court, my lord, and the said application was on contested hearing allowed by this honorable court, my lord, and the quashing of that FIR against the said petitioner was also granted, my lord, by this honorable court. My lord, I would refer to the judgment of this honorable court in Sipra Majumdar, my lord, that has been very fast, very recent, my lord, where the ingredients of section 498A has been discussed, my lord. What constitutes 498A is not mere fact of certain harassment. And he takes the third page, my lord. Para 14. Here the entire provision, 498A has been reiterated, my lord, and interpreted subsequently. My lord, in plain words, whoever, being the husband or the relative of the husband of a woman, subjects woman to cruelty shall be punished. Now, my lord, thereafter, explanation is there with cruelty clearly defined. Cruelty means. But there are A and B two. There are two conditions that are defined, which would amount to cruelty. Any willful conduct which is of a nature as is likely to drive the woman to commit suicide, or to cause grave injury or danger to life, limb, or health of harassment to women where such harassment is with an view to coercing her or any other person related to her to meet any unlawful demand. Now, my lord, these two conditions, even on plain reading of the FIR, are not disclosed, my lord.
কালকে থেকে উপরে রেখে দাও। We'll continue tomorrow.
Detail. My lord, it will take 2 years.
Sir, may I be permitted to mention before I think?
No.
Today's item number 190 is running in the list for.
No, sir,
Yeah.
no mentioning. Tomorrow.
In this case, do the court require the case diary, Lordship? Because in the supplementary affidavit, they have annexed 161 statements and the co-accused petitioner number 5, accused number 5, my lord, he was granted quash, my lord. His petition of quashing was allowed, my lord. So do we need the case diary?
You know, every 161 has been annexed.
Yeah, his 160, he has annexed 161.
My lord, there are several, few 161 which have annexed.
So you will be returning the case diary to me.
Because I have not collected the case diary, so should we bring the case diary?
No, you are not with the case diary.
I am not with the
So
case
we'll
diary.
see. If it is required, we'll find out.
Yes, that is the reason why.
Was there any direction to produce the case diary?
No, there is no direction at all.
And my lord, it can be fixed on Monday.
Yes, my lord. Monday I will bring the.
Tomorrow you will not be there.
I will be there, but if, just in case the case diary could not be procured.
Then on Friday?
On Friday, I have some difficulty, my lord, because my child's
Monday.
Monday.
My lord, can keep it at part.
Yes,
After that?
Monday.
Because there is a reasonable presumption, my lord, there is some torture regarding the.
Monday te rakho.
Case diary লাগবে এটা।
হ্যাঁ, Monday এটা লিস্টে থাকে। Monday. I'm not passing any order today. You produce the case diary on
Yes,
Monday.
yes.
If any of the 161 statements are not there in the application, we can have a look to the other.
Fine, much.
Look, I'm only praying for upgradation.
Upgrade.
Seizure of raw jewel, and it is.
No upgradation. We'll go serially.